Welcome to the Greater Irvine Chamber Business Insights podcast series, where we address challenges and ideas for early-stage and entrepreneurial business leaders. Your host today is Dave Coffaro, President and CEO of the Greater Irvine Chamber.
Well, hello, folks. Welcome to the Greater Irvine Chamber Business Insight podcast. I'm Dave Coffaro, and I'm glad to be your host today. Thank you so much for joining us. And many employers in our community are talking about what's happening in immigration enforcement right here in Orange County and elsewhere in the country. And at a local CEO and business owners roundtable meeting that I was at a couple of weeks ago, people were talking about the need for clear information about employer responsibilities and how to properly work with employees and federal enforcement agents. So that's the topic of our podcast today. Our guest is Lisa Ramirez, a California immigration and nationality law specialist and a partner with the U.S. Immigration Law Group. They're based here in Orange County, and Lisa's practice focuses on Department of Homeland Security I-9 investigations and audits, establishing compliance programs for companies, and obtaining various visas for professional athletes, artists, and religious workers. Please note that the opinions that Lisa shares today are her own. They don't constitute legal advice. If you need specific legal advice for your specific circumstances, feel free to contact Lisa or your own attorney that can help you with your specific case. So with that qualifier out of the way, Lisa, welcome to our podcast.
Thank you, Dave. It's great to be here.
So for starters, would you talk a little bit about the current immigration enforcement climate and what it looks like right here in Orange County?
Yeah, I wish I could talk about it as if it was something static, but it's something very dynamic, really changing from week to week. So I think what's very clear, and probably most of your listeners are aware, that enforcement across the board is up. And I mean that both in terms of employment enforcement and also individual enforcement. So we have a greater presence of Department of Homeland Security enforcement officers, whether we're talking about, ICE officers or HSI here in California specifically. I would say within the last few weeks that was not present here before. We'll see how long they stay, it lasts, but we do anticipate that enforcement is only going to increase. I get a lot of questions, especially from business owners, about what to expect. And what I will tell you is that every business owner really needs to be prepared and be proactive, because come the beginning of the federal fiscal year, which is October 1st, there's going to be billions of dollars really invested in enforcement. So what we're seeing right now is really just scratching the surface. But there's, more immigrants are being apprehended and detained than probably ever before. There is an increased revocation of both student and employment-based visa holders, or those that are applying for visas, whether to renew them or applying for the first time. So business owners that have employees that are foreign nationals, this is something that they really need to think twice about as to whether or not they're going to send those foreign nationals outside the United States. There's ways of, extending status, doing changes of status, but if the person departs and needs a new visa, there's a higher chance these days that those visas will be denied. So there's a higher level of vetting that's taken place. There's also kind of a crisis level of processing delays. And that really puts both employees and employers in, a bit of a predicament, because, every HR professional knows you need to re-verify those employees. And if they cannot demonstrate either a timely renewal of their employment authorization or, they'll allow it to lapse, then they're not permitted to work. So we will continue to see the elimination of those with temporary protected status, right, which is another mechanism by which foreign nationals can work here in the United States. So we anticipate employers, losing, employees that may have that status. And then I would say just overall, there is a significant focus right now in anyone, even if they have work authorization, but, what I would call recent arrivals. They've arrived to the United States within the last 2 years, despite having, legitimate applications filed and pending. The government is taking a very strong and proactive effort to revoke and deny those applications and then utilize their authority to expeditiously remove them from the United States. So we have a lot of people who are, being removed to their home country or to third countries at this time, which often leaves the family in a bit of a bind, if you will. And we're seeing more and more U.S. citizen adult children assuming the responsibilities of their parents in the absence of their parents. So lots of changes happening.
You've been at this for a long time. What's most different about the current situation versus previous periods?
What makes it most challenging is that those of us in the legal profession are constantly surprised by the lack of, kind of rules and policies really that are longstanding that we have, been used to following, adopted, trusting, really being thrown out the window.
So absent those surprises, do you have a sense for the federal government's priorities at this time?
They really want to focus on individuals that, are engaged in any type of fraud, individuals that are a risk to public safety or national security, individuals that have been previously ordered, deported, or removed, and individuals who've committed any criminal acts.
So, from an employer perspective, what are the most common reasons an immigration officer may approach your business?
Yeah, so there's really only three reasons why an immigration officer would approach any business. So one is they're there to serve a notice of inspection, right? So they're there to conduct an I-9, investigation. They would serve that notice. The employer has 72 hours in which to produce those I-9s. I really urge employers to take advantage of those 72 hours because anything you can do to review and cure any defects in your I-9s before you hand them over to DHS will be helpful. The second reason this is a very unusual reason, but it is a reason, is to conduct a workplace raid. Now that is really a bigger longstanding kind of investigation. Usually it's multi-agency. In my experience, it's typically in industries or for employers that, are engaged in, human trafficking or egregious workplace violations and conditions. So that would be a second reason. And then the third reason is because they have a warrant to search or to arrest an individual or individuals. And we can talk a little bit more if you're interested about the different kinds of warrants because they often use the administrative warrants to be able to apprehend or access private spaces. And I think what's really important is for employers to know the difference between a judicial warrant and an administrative warrant. And it's only the judicial warrants that have legal effect.
So what specific to those distinctions, what should employers know? What should they look for?
So a judicial warrant has the name of a court. It's signed by a judge, right? Those are probably the two easiest things to look for. The administrative warrants are internal documents used by the Department of Homeland Security. They have a signature, they have a date, they have the name and, perhaps the alien number, the address, but consider those more like internal marching orders, like from a supervisor to a, deportation officer to go out and apprehend. But it does not in any way require the employer to give access to space that may be listed on any administrative warrant or to help facilitate direct ICE in the arrest or apprehension of an individual on an administrative warrant.
Okay. Thank you for making that distinction. I think that will help the employers on the phone understand that difference. How should businesses prepare for potential immigration enforcement visits?
I think it's super important for every business owner, regardless of how big or how small, to be proactive and just assume the possibility that they may be visited by an ICE agent, sooner or later. And I think that you want to make sure that I would say first and foremost that you have a clear understanding of what constitutes a public space versus a private space on your property or your campus, right? So why that's important is because no federal agent can access a private space without a judicial warrant, right? But some of those spaces can be hard to define, and there's no, black and white legal definition. But generally speaking, a private space is a space that someone off the street, a customer or a client, would not be able to access. So to use the example of, a restaurant, the dining area would be considered a public space, the parking lot, probably a public space, the public restroom, potentially depending if they're locked with a code or not, would be considered a public space. The back office, the kitchen, if it's locked, if, no one can just kind of wander back there, that would be considered a private space. But we really encourage employers to get signage on areas that might be gray areas. So places and spaces that might be locked. We represent a lot of colleges and universities. I would say they probably have the most gray areas where, libraries, campuses are open, people can walk on, libraries, have automatic doors that open. And so more and more colleges and universities are utilizing signs to indicate, this libraries for registered students only, or not open to the public, or trying to make clear locking areas that they weren't accustomed to locking. They're redefining what classroom space is depending on if people can come in and just sit in on a class. If that's been allowed previously, they're kind of not they're no longer allowing that to happen, that you need to be a registered student in that particular class. So first and foremost is just be clear about what the private and public space is. Secondly, I would say is to develop internal policies and protocols, right? I think what's really critical, the business owner, the manager, the person responsible for operations, they may have an idea, but unless your staff has been fully trained and informed about what that policy or what the protocol is, then I think it's a great disservice. It's as if it exists on paper, but not in reality. So I will tell you, it's the frontline staff that are probably the most critical. It's your receptionists, it's your cashiers, it's the people that are going to engage or interact with the public. If they don't know how to respond or handle to an agent coming and visiting your place of business, to know not to answer questions, to volunteer information, to provide documents, to lead them back to a person that they might be interested in speaking with or questioning, then that is the beginning of potential violations, right, for that employer, at least under state law. So you want to make sure that you have very clear, policies and protocols written, and that there's an understanding of what those policies and protocols are. So they know, okay, this is who I call, whatever the chain of command is going to be, whoever's going to be the person that's going to be the one to interact and engage with ICE. You're just not going to want to leave that up to anyone who may be physically present at the time that they at the time that they visit. So having those policies and protocols, in place, in writing, and with the training are really important. You want to make sure that people are on alert as well when they see vehicles, and especially these days, it's very difficult because they're not marked vehicles, but any suspicious vehicles, dark windows, unmarked cars, so that management can be aware that there could be potentially, an ICE presence, at the workplace, on the campus. You want to also make sure your I-9s are in order. If you haven't done an internal audit, I would say this is the time to just take a look at it. Do a sample audit. If you have a lot, if you have thousands of employees, just look at 10%. Have, a third party just take a look, make sure you've got your I's dotted, your T's crossed, because even if an employer is 100% compliant in the sense that they do not hire and they have no employees that are unauthorized to work, they can get hit with substantial fines as a result of substantive and technical deficiencies on their I-9. So sometimes it's just paperwork mistakes, or they use software and they started different softwares over time and they can't produce the IP address stamp or the software doesn't have the reporting, requirements that ICE, demands. So just making sure that you got your ducks in a row with the I-9s.
Policies, protocol, and internal audit. Those are the key themes I heard you say, Lisa, and I think those are so important. Thank you for clarifying that. One source of confusion for some employers is differing messages from the federal government versus the state of California. How can businesses reconcile these two?
Well, I would say there's really nothing for businesses to reconcile. If there are conflicts, it's really a legal question and issue that has to be challenged in the courts. So businesses are obligated to comply with both, right? So the federal law trumps state law. But what I will say is here in the state of California, what we have and what we often see, especially when it comes to a variety of different laws and employment laws, is that, the federal law establishes the floor, but it's state law that establishes the ceiling, right? So you really need to, even the baseline for the federal government, be very low. The analogy that I like to use is, if the sky is falling and the federal government says, oh, the only thing employer needs to do is provide a baseball cap, but California comes in and says, well, no, they need a hard hat, they need an umbrella, they need shields and, additional protective gear. Well, that's just adding to what the minimum was required by the federal government. So what do employers do? They have to do it all. They have to basically, if you're meeting the state standards, you're typically complying with the federal standards. There's usually not a conflict. You have to be compliant with both.
Great analogy. That works for me. So last question I have for you, and this is not directly a legal question, but some employers tell us that their employees are experiencing fear surrounding these enforcement actions. And while that's not directly an immigration law question, are you hearing best practices for how firms are navigating this to help deal with their employees and help them recognize what's going on and do so in a fashion that helps them alleviate some of the fear?
Yeah, so that's a bit of a challenging question because I've heard so many stories. What I try to tell employers is please treat any issue, concern as you would normally. And I know this is not a normal kind of environment or climate that we're in right now. You need to treat those things as you would as any other type of, hostile work environment. You want to avoid discrimination and retaliation issues. Now, the other piece of it is, it's really important to be consistent. I get questions a lot like, should we allow, employees to have, time off, or how do we treat when they're too afraid to come to work? And I say you need to be consistent with your own policies, right? So if you've got a PTO plan, maybe that's something broader that lets, employees have more flexibility as to how they choose to use their time off. But if it's like a sick or a vacation, right? And this is this is a little bit outside the box. That's really an employment law question, but also an internal discussion that needs to be had. And you just want to make sure that you're being consistent and that anyone else who has, say, a concern or a fear for not showing up to work, you're not allowing it for one person and not another. So I would say consistency is very critical. So just make sure that you know what the policies are, you're consistent with them, you avoid discrimination and retaliation in the workplace, and you should be okay. I hate to say it's, business as usual, but just try to stay focused on whatever the HR policies that you have in place.
I like the theme compassion and compliant. So know your policies, follow the rules, and be compassionate. Lisa Ramirez, U.S. Immigration Law Group, thank you so much for being our guest today. We appreciate you sharing your insights.
Thank you, Dave. Thank you for having me.
Thank you for joining us for the Greater Irvine Chamber Business Insights podcast. To stay informed about upcoming podcasts and other important business news, please subscribe to our channel or check the Greater Irvine Chamber website.